Welcome to Southwest Florida Real Estate Update, hosted by area realtor Jim York and York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information about the local real estate market, featuring leading experts in the real estate field.
Good afternoon and welcome to the Southwest Florida Real Estate Update. I'm Michael York with the York Real Estate Group, and I'm joined today by our host Jim York and his guest Don Ross of Ross Title and Escrow.
Thank you, Michael, for the introduction. Well, Don Ross, it's our monthly show,
Jim?
Right? Okay,
Yes,
so tell our viewers that haven't seen the show a little bit about yourself.
I'm a local attorney. I've been a member of the Florida Bar since 1982. I have a degree in taxation. I'm one of the owners of Downing Fry. I have my own real estate firm, title company, law firm. I've been in-house counsel for Downing Fry for 25, 30 years. The title company has 8 employees. We're right on 41, corner of 6th Avenue North and 41. Most of them have been with me for decades. So we have a pretty good operation.
It definitely is a good operation.
Thank you.
Clients have been very happy with you.
Thank you, Jim.
So, well, let's talk about today. We've gone through, or we're almost through 2017 here.
Yes.
So you doing a lot of closings and I'm doing real estate contracts or listings. Let's summarize the things that you have seen that maybe in 2017 that maybe are the biggest mistakes or people aren't paying attention to.
Well, the first thing that I see is that people who sign contracts don't necessarily understand what they're signing. There's no real explanation of what is considered a working condition and is therefore acceptable under the terms of the contract versus cosmetic condition.
That's right.
When is something considered broken for purposes of the contract versus not broken? So you end up getting a lot of agents and buyers doing their buyer's request. We have a specific form under the Naples Board of Realtors where you use this form, buyer's request and seller's response, when you want the seller to fix something. Okay, it could be a broken air conditioner, it could be elevated radon, it could be elevated levels of toxic or pathogenic mold, it could be a million things. And unless the working condition provisions of the NABOR contract, and this is the NABOR contract, are explained to the buyer up front by the agent, you get a lot of buyers who think that they are actually entitled to a brand new air conditioner.
True.
Or they're entitled to have their screens, if you have a hole in the screen, if you have a missing screen, they're entitled to ask to have that rectified. And under the NABOR contract anyways, missing and torn screen is not considered something that's a defective item, much to my surprise. It's an arbitrary designation under the contract. Now, I get a lot of what we call FSBOs, for sale by owners, where I have all 4 parties around the table, and I'm able to explain what the buyer is entitled to under the definition of working condition and what he's not entitled to under the definition of what's cosmetic.
Right.
And their expectations, the tone is set up front. If you don't set that tone and somebody makes a request, you run into 2 possible problems. You might get a seller agreeing to fix something that they never had to. And then they might find out later on that they essentially overpaid by fixing things they didn't have to.
Right.
And they'll find out at a cocktail party or some function after the closing, and then they're going to be irritated with their realtor, and they'll raise a ruckus. Or people will just get into a rip-roaring argument over, the air conditioner or whatever it is, and the emotion takes over the deal, and it's hard to get it back into a level playing field.
So what I normally do myself is I either send them a copy of the contract prior, okay, so they can read it over. And then when I meet with them to do the contract, I explain, because the inspection is the big problem most of the time. I explain to them what you just said, okay? And I also tell them, I take it one step further, that when you do a home inspection with an inspector, his software comes back that says defective items.
Right.
Okay, it's not tied in with our contracts. So that results in a lot of problems because
Right.
they say, well, it's defective, they should fix it. Well, he doesn't have the difference in his software what's cosmetic and what's defective. So that's, if it's not explained properly up front, it can be a huge problem for people. I've been lucky because we've been experienced, my son, my daughter and I, explaining this to most of our buyers or all of our buyers. So
I had it this morning over polybutylene.
Did you really?
A Cleveland attorney calling me. The seller is his sister is the seller, and then she's going to sell and go buy something else.
Right.
And the buyer on her sale is asking for the polybutylene pipe in this, which has been in this condo for 20 years.
Right.
Be replaced.
Right.
And I had to explain, actually the agent even didn't know this, and she's been an agent for probably 40 years. And I had to explain that it's not, polybutylene is not treated under the NABAR contract.
No, it isn't.
You can't find it anywhere in here.
Right.
It's not considered a defective item. And the seller's disclosure that goes with this NABAR contract specifically deleted the reference to polybutylene early this year.
Right, they did.
So,
Right.
you know that sort of thing I get on a daily basis.
So the next question that we're going to go to, but before we go into that question, I just had one more thing, is to avoid all these problems.
Yes.
Is to do an as-is contract. And maybe just explain that shortly, what the advantage may be of an as-is contract.
Well, the as-is contract I both like and dislike. The as-is contract gives the buyer the opportunity to terminate the contract in buyer's sole discretion. Those are the operative words. And it's both NABAR, the Naples Board of Realtors, and the Florida Bar, Florida Association of Realtors contract. They both have as-is contracts where the buyer has the chance to terminate for any reason whatsoever in buyer's sole discretion.
That's right.
I refer to it as the free look provision. The advantages to it is that if you have a subjective issue in your family, and I've had clients, for example, who've had a breast cancer operation, and they had elevated radon reading, and the buyer didn't care if the radon was remediated, was just too traumatized by what she just went through, and understandably so, that she would worry that the radon remediation device might stop working at 3 in the morning. So she wouldn't want it. So the as-is provision would allow somebody like her an opportunity to say, yeah, I don't care if you do fix it, I've just been through this horrific life event, I won't be able to sleep nights no matter what, I don't want to buy it, and then she can terminate. Or you have, I have this with my son in Atlanta. He's a real estate attorney in Atlanta. They bought a new home, he and his wife. They have 2 children. The youngest is a few months old. I'm going to see him in a few days. But he has allergies, and there was some mold in the house, and it's Penicillium aspergillus, the plant decaying matter. And I had to explain to my daughter-in-law, who's a nurse, that this is something you and I deal with all the time. We live next to the Everglades. We're in a semi-tropical climate. The leaves and palm fronds and so forth do die and they decay. That's part of nature's process. And it results in particles floating through the air of this Penicillium aspergillus. And some people are allergic to, just like I'm allergic to penicillin, or I'm allergic to peanuts and things like that. So it gives somebody who has an allergy, who just went through a cancer operation, who has some other personal issue that we wouldn't consider an objective objection, an opportunity to terminate the contract and get their money back if the property doesn't fit what they're looking for.
Yeah, and just to summarize this before we go to break, is that 15-day look, you can cancel for any, terminate for any reason, okay?
Sure.
And you can still go back to the seller and ask them for these repairs.
Oh, absolutely.
So sometimes that they don't want to lose the sale, so it kind of worked to your advantage in a way, rather than the regular contract, you're limited of really what they're obligated to fix.
Yeah, depending upon what it is, the seller's in a box if it's something significant, because now the seller knows about it and they're going to have to disclose it to the next buyer.
Exactly.
But I get many situations where the buyer says, the seawall just is eroding because of Hurricane Irma, and we need a credit for $5,000, or I hereby terminate.
Right.
And that you can do that within the 15-day period.
Okay, Don, we're going to take a little short break, and we're going to be back in 1 minute and finish up some of these topics. Thank you.
Thinking of buying or selling a home in Naples, Marco, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group associated with the #1 brokerage in Naples, Downing Fry Realty, which produced $1.9 billion in sales in 2014, controlling 43% of all transactions in Naples. Jim, Michael, and Morgan York make up the York Real Estate Group of Downing Fry Realty. With over $250 million in sales transactions, they can offer you the expertise and trust you want and need in a realtor. Call them today at 239-273-6727 or visit their website, www.naplesyorkrealestate.com.
Welcome back. Don, let's talk about credits on repairs.
Sure.
How's that handled?
Depends upon whether or not the buyer is getting a mortgage. Lenders generally do not want to see anything relating to repairs on a closing statement.
That's true.
They're going to put a mortgage against the property. They've had the property appraised. They've had the person's personal financial situation evaluated. And in order for them to underwrite the loan, they need to have at least the perception that the property's in tip-top shape. That's perfect. And the last thing you want on a closing statement that involves a lender is a repair escrow for a leaky roof or for termite repair, something that would throw the underwriters into a fit. They would lose their. It doesn't. It really. These people are so detailed that you breathe that there's something not absolutely perfect. That they go crazy. So I recommend to my buyers that one of the first things you want to do is talk to your lender. Make sure that you do qualify for a loan of this particular size. That just because you have $10 million in a 401k doesn't necessarily mean that you have a sufficient income to qualify for the loan. And then if you have run into a repair issue, let's say there was some air conditioner that needed to be repaired, and the seller's agreeing to give the buyer a $3,000 credit. You don't want to put in the closing statement that a seller credit of $3,000 for a broken air conditioner.
Right.
And you have to run this by the underwriter, but what you generally do is put down that it's a credit for closing costs, prepaids, and escrows.
Right.
And before you agree to that, you need to at least have a cover letter from the other side indicating that in lieu of that credit for closing costs, prepaid, and escrows, that they're waiving any claim for repair credits, because you don't want them asking for both, because occasionally people get greedy. So that's a huge thing, being cognizant of the lender's perspective, that they live in somewhat of a dream world, that everything is perfect.
And that's the same with furniture too.
Oh, it's exactly the same. I mean, if you're going for a 30-year mortgage or even a 15-year mortgage, I mean, how many couches last 30, 15 years? They're not lending against the furniture.
No, they're not.
They want it to be strictly against the real estate. They have their Fannie Mae, Freddie Mac guidelines they have to comply with. They have the levels of due diligence they have to do as dictated by Dodd-Frank. And they want to make sure everything is perfect and it's just the house and there's no chairs or couches or tables or stereos that go along with the transaction.
I know this isn't on your list today, but let's just, while we're talking about contracts, let's just shortly talk about developer contracts. Some what they should be watching for our buyers or sellers or realtors about developer contracts.
I had one this morning. I regularly review developer contracts, and I don't charge a dime for it. As you and I both know, the developer contracts they're like thick. They're thick. I mean, they're incredibly thick.
It's one-sided.
They're entirely one-sided, and they have 4,000 addenda, and then they have all the specs of what's being built, what types of appliances and so forth are going in the property. And the conversation I had this morning was with a Cleveland counsel What I told him, one, I knew who the developer was, and I said, down here in Naples, it's a different world. You want to do your due diligence on the developer. And before you even look at the contract, you want to know the reputation of the developer. Go knock on the door of one of your future neighbors, bring a bottle of wine or a pound cake or whatever it is, and break bread with your neighbor. And in the course of conversation, after the first glass of wine, because you're going to know each other anyways, you might as well meet them now.
Does it work if you drink scotch?
Yes, that works even better,
Okay.
actually. But I mean, you're going to meet the people anyways,
right.
and you want to know, is this a nice neighborhood? Is this, people get along with each other, or is there one crazy person
Right.
on the street? And then you can get into, what was it like for you when you bought from this developer? Did they complete the punch list in a timely manner? Did they allow you to have a third-party inspector come in and assist with the walkthrough, which
Right.
is a huge thing. And with this gentleman, I told him, just check with your neighbors. And I'm sure you'll find with this developer that they are very cognizant of the importance of their reputation. They want you to refer your friends to this development. They want you to buy other properties. They're like Pelican Bay, people buy and sell multiple times. So once you get through that, it's easier to swallow the fact that the contract is so one-sided, which it absolutely is.
Yeah, and you really can't change it. So the best thing
No.
to do is get that contract prior, ask them to email to you. Somebody like yourself can look at it. Really, a real estate agent like we can't give them advice on that, so they need to have counsel.
Well, this particular example,
So-
he had his wife taking title, and we talked about homestead and whether you got to talk to your estate planner and how you
Right.
want to take title and how the Florida Constitution works. And we also talked about he wanted to take title in a trust, his wife's trust. And I said, again, you need to talk to your estate planner.
Right.
It's part of their overall financial scheme. And what I generally ask for is just the first page of the trust. And I also told him, make sure it's a revocable trust, because that's what the appraiser's office looks for. If it's an irrevocable trust, now they got to look at who the beneficiaries are, and it may or may not qualify for a homestead. So we had that very long conversation, put the man at ease, reiterated that we both hate arbitration because it had an arbitration clause in the contract.
Right.
But he was comfortable enough that he's going to do the walkthrough tomorrow and go forward and do the closing.
Good. Well, what do you have next on your list there?
The proper way to make an election for repairs and respond to repairs. We added in 2014 to the NABOR contract permits as something that you can inspect for. This is the NABOR contract, this lovely document, and this is the FAR Bar, the Florida Bar, and the Florida Real Estate Commission contract. The FAR Bar contract has always had permits part of it. It's one of those three categories that you
Right.
can inspect for. The NABOR was just added in 2014. So what I try to educate people to do is that when the buyer is notifying the seller as to whether they want a credit or remediation, you got to throw the permits, the open permits in there too.
Right.
Because the permits are under the same category as a defective item in the NABOR contract. It's in the same paragraph that you would find radon or mold or a leaky roof. So you have to notify the other side that you want the voided permit or the open permit closed within the 20-day period. The seller then has 10 days to respond. If the seller fails to respond, that's a no, and then the buyer has 5 days to cancel. What I'm seeing a lot of is everybody's ignoring the permits, and they're doing the air conditioner with one form, and then they're handling the permits with emails or correspondence, when really it needs to be within the same time frame. I've had many situations where I've been on the seller's side, and at the last minute, the title company on the other side will ask for this particular permit to be addressed. And it's like 3 days before closing, and it's way past the period of time where you can ask the seller to do anything.
Right.
And we generally respond, because we try to be nice, that we will try. We're going to ask our seller and see if we can clear this up for you, but we are not required to do this. We're just doing this as a courtesy.
So when you do a contract and It's important for the title company or whoever's closing to do that search relatively quickly.
Yes.
That's what you're telling us.
We do it automatically. What fails to happen in many cases is, new agent, and we got
Right.
maybe a couple thousand new agents, will not communicate with us,
Right.
and they'll go ahead and have their inspection. They don't say boo to me or
Right.
anybody, and they'll ask for things without even knowing whether they can
Right.
ask for it. And then the seller will respond by saying, yeah, we'll fix it, which is very vague and general. What's fixing it entail? And they'll leave the permits out entirely.
Right.
Nobody even knows about it. So
Right.
I'm handling that on my own. It's not a coordinated effort.
Right.
And unless you get it to the other side early. I mean, I have my ladies trained that if we ask somebody to close out a permit and we hear nothing for 10 days, that's a no. We calendar it,
Right.
so that we can warn our buyer that, hey, you have the right to terminate the contract. And we try to look not only at the fact that there's an open permit, but what is it for?
Right.
I mean, is it for some minor thing like a 23-year-old sprinkler system, or is it for a new kitchen and bathroom?
Right.
Or something
Major.
significant.
Right.
So I really try to put it in perspective for my buyer on whether or not it's a big deal, a little deal.
Well, the bank won't close if it has an open permit.
No,
will it?
actually they will.
They will?
That's I get that quite often. The bank doesn't know. The permit is not a title issue. It's not necessarily in the public records. It's just something that was added in 2014 to the Naples contract as a repair item that the buyer can inspect for. And the seller can say no, and sometimes my sellers do, like for shutters. We get a lot of 19-year-old shutters that they never CO'd. And it's $1 million condo, and you're not going to get an engineer out there, especially after the hurricane. And we just say no, or we might offer a small credit just as a courtesy so the other side doesn't feel disrespected.
Well, Don, we're going to take another little short break,
Sure.
and we'll be right back, and we'll finish up some of these important questions with him, okay? Thank you.
Looking for a real estate closing agent in Southwest Florida? Ross Title and Escrow has over 25 years experience and has closed over 20,000 residential real estate transactions. Donald Ross Jr., president of Ross Title and Escrow and a practicing attorney in the state of Florida with a degree in taxation, is here to service your needs. Call Mr. Ross or one of our 4 closing agents for a free consultation today.
Welcome back. Don, let's talk about missing parties. Explain that.
Again, I had this one this morning.
You've been busy this morning.
I get these all the time, and this is a recurring thing. Part of this is that we have 50 states in this country, and each state treats real property law differently.
They do.
So you might as well be France or England. And actually, we get France and England on top of that.
Yeah, we do.
People. I mean, the agents. God bless them. They. Again, we got 6,500, maybe 2,000 are relatively new. There's a handful that went to law school, believe it or not, and they'll just look at the deed, or they'll listen to their client as to who owns the property, and that's who they put down as the seller. And the people may have been living there, it may be their homestead, and it might be in a trust. It could be in a revocable trust, and you still have a wife and children living there, and the kids are going to school and so forth, and that's homestead. And as I was explaining to I keep picking on my poor Cleveland attorney that I spoke to this morning. I said, regardless of how they do it in Ohio, here in Florida, they made an effort years and years ago to protect families. So they passed Section 4 of Article 10 of the Florida Constitution that requires the joinder of one spouse. Let's say my home was just in my name, and I wanted to mortgage it, or I wanted to devise it or will it to somebody. I need the joinder of my wife, Coletta, to do that. And the point of all that is so that she is protected and my children are protected in case I do something silly, which I'm eminently capable of doing something silly. It's to protect the family unit.
Right.
And we've all seen those movies, at least I have, where the poor widow in Ireland, I don't know if you've seen this one, where her husband passes away and she finds out her property is mortgaged to the hilt, and she has to go out and do something illegal to help pay the mortgage payments. So this requires your spouse to be involved in the conversation on whether or not you want to refinance the house so you can fund your business,
right?
You know, which would happen quite a bit.
Exactly.
And you got kids there. Do you gamble the equity in your home in order to make a business investment, which people do? So, you know, I tell the agents, you know, rather than them knowing everything there is to know about homestead, which is incredibly complex, I was telling one Saturday that, you know, if in doubt, get too many people to sign the seller's side of the contract.
Right.
If in doubt, get more.
Right.
I'd rather have too many people signing than too few.
Right.
Because you could spend money advertising, you could be doing open houses, you can be working your tail off, you get a signed contract. Title company, me, lawyer, whoever, does a title insurance commitment, and you find out that somebody else has an interest in the property.
Right.
And that person doesn't want to sell. So
Right.
everything you've done is a total waste unless you get that person to cooperate and sign. It's a common thing.
Well, the last thing I think is very important is communication, because you know, there's lots of moving parts, and we're trying to do things in a time period, and if you don't have good communication with all the parties involved, buyer, seller, attorney,
Sure.
closing agent, inspector, insurance people, it's
Right.
mortgage people, it's tough, isn't it?
Well, it's part of your mantra on having a team.
Right.
I mean, you and I have worked together a long time,
Yep.
so you know, you have a particular lady in my office.
I do.
She knows what Jim wants. Jim knows what she's going to do. You know, you can get me 7 days a week. I'm not shy calling you. I called you
No.
on the way in this morning. You're not
Exactly.
shy calling me.
No.
I get a lot of people who, I don't know whether it's because I'm an attorney or because I'm a man, I don't know, but they don't want to bother me on a weekend. They hesitate to ask a question, sometimes I think because they feel foolish that they don't understand this. And I try to reassure people of 2 points. One, I do this, you do this
That's
every
right.
single day, all day long. Most people only buy 2 or 3 properties their entire life. So just by sheer experience, we're going to know more. It's not that we're Leonardo da Vinci, we just have more experience. We've done it 10 bazillion times.
Right.
So don't be shy, call. I don't do what you do for a living, and you don't do what I do for a
That's
living.
true.
So, you know, I can't expect you to know everything I know, and vice versa.
Plus, certain things don't come up all the time. I mean,
No.
I've been doing it for 20 years, just in Naples, or 21 years, and you know, it's just something that might come up once every 20 years.
Well,
you know what I mean? So-
the odd thing is, like we had the mortgage fraud situation going
Right.
on during the recession, and I started out as a criminal defense attorney. I mean, that's what I did. I did tax fraud defense and things of that sort. So it's kind of enlightening to me that something that I did when I was 28 years old now is becoming relevant all of a sudden in the context of a real estate practice.
Right.
I mean, I know the significance of lying to a bank and what that can do to you. I know people who've been indicted for lying to a bank.
Right.
I've tried people who are, you know, supposedly lie to a grand jury and things like that. So you and I, we've done it for such a long period of time. It's funny what triggers in your memory cells from 20 years ago.
True.
You know, when something happens.
Right.
And to be able to draw on that is a huge asset. But I really, people get intimidated by, you know, they don't want to look uneducated, or, you know, I'm a lawyer and they don't want to bother me on weekends. And you know, calling me on a Monday is, for me, more of a burden than calling me on a Saturday.
Right.
'Cause,
But you're unique, let's face it.
well,
I
I'm
mean,
different from other people. I don't
Well, you
know.
know, lots of attorneys you don't want to call on a weekend, so that's why we do so much business with you, and lots of other people do a lot of business with you, because you're just a phone call away or a text away, or, you know, and that's how you got to do business in today's world. People want answers quick, You know, they want results quick
Yeah.
because of the technology we have today. You know, people
Well,
are impatient.
You got the
So-
technology, and what I've learned just through sheer experience, I learned this from my father too. He was a builder, just like you were a builder.
That's right.
If you get to the question early, it doesn't, the anxiety doesn't escalate.
True.
And it becomes a non-issue. If you wait till Monday, they've had a whole weekend of lost sleep and they're semi-psychotic by the time they get you on the phone Monday, and it becomes a big deal-breaking
deal.
issue. So one, I get it out of the way more quickly. It's
Right.
easy for me to deal with Saturday morning, 2 minutes on the phone. 2, my client stays nice and calm. And 3, I don't have 3 times the number of phone calls Monday morning than I normally would if I made everybody wait till Monday.
Right.
So that part of it's selfish on my part. It spreads the load out a little bit, and it makes it Mondays easier.
Well, Don, thanks for coming on the show.
thanks for having me.
You've been very helpful, and maybe, I know we didn't finish up everything, but maybe in one of our future shows we
Sure.
can finish it up.
Sure.
Thank you for tuning in today, and see you next month with Don.
Hey.